Yes, Mr. Firth.
Before lunch, I showed you the explanatory notes in the budget. Consistent with equivalent data, I say those are the assistance to the court identifying the purpose and mischief of which this legislation is directed. I now propose to show you briefly, if I may, the structure of the ranges litigation, in the sense that you can see in the first two levels, HMRC were only arguing that the payment by the trust should be treated as earnings, and it's in the Court of Session 2015 that changes. I'm hoping the FTT decision is at the back of your first authorities bundle. Begins on page 296. And it's page 328 that I'd like to briefly show you. If I may.
Hold on a minute. So, reg number 296.
Yes, my lady.
Was it called Murray Group?
Yes, yes, it was, my lady. And it becomes RFC 2012 in the Supreme Court.
It's 308.
328, my lord.
328, sorry.
Paragraph 147.
And paragraph?
147, my lord.
Yes, I have that.
This is under the heading Respondent Submissions.
Yeah.
Thompson's submissions depend on detailed factual findings about the functioning of the remuneration trust. He saw it as a mechanism for placing cash unreservedly in the hands of the employee, together with the advantage of avoiding tax. And the evidence led by the appellants tended to conceal the railway in which the trust operated, and then there's arguments about the nature of that evidence. If we then proceed forward to 155, please. Mr. Thompson then addressed the nature of the scheme. It was a bespoke package. Its whole purpose was to put cash in the employee's disposal. That he submitted was achieved when payment was made into the particular sub-trust. At that stage, the money was unreservedly at the employee's disposal. And that ties in with the spotlight I showed you, where HMRC said, well, our view is that the tax charge, its employment tax, arises at the point it's put unreservedly at the disposal of the employee. You can see HMRC presenting that argument to the First Tier Tribunal.
So they were saying the focus point is when it goes into the trust.
No. So the sub-trust, so it goes into the trust.
Oh, into the sub-trust.
And then it's put into the sub-trust for a particular footballer or their family. That's the point at which it's unreservedly at the disposal. That was the argument then. So not the way into the trust, when something's done with it within the trust. If we could then move forward, please, to the Court of Session. That should be in your second bundle, beginning on page 442.
It's at the back of my first.
So this is tab 25, so it starts at page 487. Am I on the right one?
No,
Oh, no, that's the wrong one.
442 in Court of Session.
440.
442, my lord. It should be tab 20.
Oh, I see. It's now called something yet different.
So it's now Advocate General for Scotland against Murray Group Holdings. You can see the fifth respondent.
Yes. Right. So this is the outer house? No,
This would be the inner.
The inner house, yes. Right.
Inner house, my lord.
Thank you very much.
So this is equivalent to Court of Appeal stage.
So we've missed out the Upper Tribunal. Wait.
Well, it doesn't advance matters. It followed, I think, the same line as the First Tier Tribunal. The point of showing you this is the first point at which the argument that was the way into the trust is developed.
Right. And where do you want us to read?
Go to page 451, please.
451. Very unhelpfully, this bundle ends at 450. I've got to go to the next one.
That is quite long.
451, yes.
Paragraph 36, parties' arguments on appeal. HMRC have appealed against the decision of the Upper Tribunal on two grounds. First, it is contended that the payment of the monies by the relevant employer to the principal trust or alternatively the appointment of monies by the principal trust to a sub-trust, constituted payment of taxable earnings, taxable in the hands of the employees whose services were so rewarded. So you can see that's now the argument. And then there's a preliminary issue as to, at 39, you can see there's whether HMRC should be allowed to advance this new argument.
So they say of the two alternatives, HMRC are now submitting that the first should be preferred. In other words, they say that it's the new argument which they think is their better argument.
Yes,
This is the first time
and
it's
that's what
been
they
right.
succeed on, yes.
Yeah.
This is the first time, and that's why there's a discussion at 39 as to, well, should we let you raise this argument at this stage? Answer is yes, that's at 39. And then if we could look, please, 56 to 57, where the court accepts the new argument. That's on page 456.
Yes.
And you see at the very end of 57 that it seems to us to be what happened at the first tier and the upper tier. They overlooked what the Court of Session, not the Supreme Court, said was a fundamental principle. But that does give context to what was considered to be, or thought to be, the potential problem in 2010 and 2011 when this legislation was introduced. It was thought that there was a problem, that if somehow you pay the money to a third party, that escapes taxation.
So the legislation was introduced before this was heard, yeah? Is that right?
No, the legislation, this arrangement was entered into before Part 7A, but the point I'm making is that...
No, sorry, we're at cross purposes. Do you mind if I just
apologies.
pause you there? I'm just trying to get the sequence right. This legislation was introduced, I thought I had in mind 2011.
Yes.
And this case, as far as I can tell from the index, was, at least it was after 2014. So is this one of these instances where the government legislated while the case was going through? In fact, where it all landed up, you didn't need the legislation to deal with that particular case. Is that right? Is that one anyway?
That's right, my lady. So you've seen the spotlight in 2010 saying we are attacking these arrangements and we're also legislating. Later in 2010, December, we get the legislation that comes into force partially in December, but then fully from April 2011. And the decision in Ranger's first tier is in 2012. So it's dealing with it in two ways at the same time.
Two prongs at once,
and
yeah.
Of course, the revenue lost at first tier and upper tier in Rangers. So
exactly. So they needed their legislation.
Cause to be concerned. And interestingly, well, when we'll get to the Supreme Court now, if we may. That's page 491, which I'm hoping is in your second bundle. So later on in the same bundle.
Sorry, which page is it?
491, my lord. We can see the beginning of Lord Hodge and his decision in the Supreme Court, now called RSC 2012.
Yes.
You can see at paragraph 3, the Advocate General for Scotland, on behalf of HMRC, appealed to the Inner House and advanced a legal argument which had not been presented to, or at least not been developed before the tribunals, namely that the payments of the sums to the Remuneration Trust involve a redirection of the employee's earnings, and accordingly did not exclude those earnings from the charge to income tax, which confirms the point I've just made. And we know we've seen from the first year's own consideration of this case in our appeal that the Supreme Court agreed with that argument, upheld the Court of Session's decision. It did refer to our legislation at paragraph 70 on page 510.
Yes. So they were dealing with prior legislation.
They were dealing with the general charge to
Yes.
employment
Yes.
employment tax on earnings, yes. And they found that it is net in respect to the payment in, and we've had that argument in this case, and the first term the upper tier have confirmed that doesn't apply.
Yes.
And it's interesting that it was at this point between the Court of Session and the Supreme Court that Parliament then took steps to say, well, we need to deal with double taxation of the payment into the trust. I don't know if HMRC want to hand it up now. They handed it to me at lunchtime. It's subsequent legislation, so my submission can't really help you very much. But at this point, realizing that, well, if we tax the payment into the trust as employment tax, and then we also tax relevant steps taken by the trust to employment tax, we've got a double charge. And at that point, realizing that in 2017, there was at that point provision to deal with double taxation by reference to the contribution to the trust. But that is subsequent legislation, and my submission can't assist with the original meaning of this legislation. So we've seen the background materials, which we said admissible under Cobalt and similar, showing that the general nature of what Parliament's trying to catch here are rewarding employees through third parties. You can see the Supreme Court at paragraph 70 saying it's designed to catch loans to reward employees. And so this is all consistent, we say, with our suggested interpretation, and equally provides no support for catching payments when employment's not part of the reason. I think paragraph 34 of my skeleton argument now, this is the point I've just made, is consistent with the fundamental structure. So the idea that the purpose of this legislation is to deal with employment income being routed by through third parties is entirely consistent with what you've seen in the structure of 554A, where you have a relevant arrangement, you have, it has to relate to the employee, and then crucially, you have to have a relevant third party, and they have to take a relevant step. And that all fits with this idea that we're trying to give effect to the policy, the purpose of catching employment income routed through third parties. So what we don't see is any reason to think that Part 7A is aimed at catching payments that aren't to do with employment, where employment isn't part of the reason. The problem with extending it in that way, in the way HMRC certainly seek to do, and the Upper Tribunal seems to do, but it's not very clear in what direction, is any analysis then of whether this payment is in connection with employment becomes unanchored, because we can't hold on to a purpose and say, well, we're comforted by the fact that our interpretation and our application to these facts fits with that purpose, because there is no purpose that supports that approach. This is necessarily a situation where employment is not part of the reason for the payment, but for some reason it's being argued it should be taxed as employment income under Part 7A. What is the objective basis for testing whether that is a sufficient connection? How do we know? How can we test that? How can taxpayers know? How can the revenue know when they're applying the legislation? And how can the tribunals work it out? Because there is just nothing in the background materials of purpose that assists us in understanding whether that's a sufficient connection or not.
Isn't essentiality the answer to that? Isn't that what the statute tells us to look at? Whether the essence of the arrangements was the connection between, not the cause of, the connection between any loan, let's say, and the situation of employment.
But
If that wasn't, then that's the line.
I mean, I think I'd agree with that. But the question I pose rhetorically is, well, what type of connection are we relying upon at this point? And it's not a connection in terms of the reason for the payment, because by definition in this scenario it's not part of the reason. How in that situation can employment be part of the essence of the arrangement? It's very difficult to see.
Yeah.
And equally, we've seen throughout, well, this is targeted at avoidance of employment taxation, avoidance of PAYE, avoidance of NICs. How can you be avoiding, or Parliament thought you might be avoiding, PAYE or NICs if employment's no part of the reason for the payments? I mean, it's very difficult to see what we're getting at now if we move away from what is obviously what Parliament had in mind. I turn then, if I may, to the second limb of this ground at paragraph 37.
Yes.
Once worth an argument, which looks at the surrounding wording. And we know from London Luton Hotel that the context can provide shed important light on the correct interpretation. And we make a number of points. First, it's difficult to conceive, we say, how a reward or recognition could be in connection with employment if the employment was not part of the reason for providing reward or recognition. And you can see, I quoted it at 37, but that's from 554A1C. Rewards, recognition, or loans in connection with employment. A reward in connection with employment or a recognition in connection with employment indicates the type of connection is, well, employment's going to be part of the reason. That just stands on its own. It would be surprising, therefore, if when we get to loans, some other types of connection are admitted that we can't readily identify that go beyond being part of the reason. The second point is a point I've already made at 39, which is that if a relevant step consisted of an outright payment, well, the way it would be caught in 554A1C is under the rewards or recognition. It's not a loan. And if it's accepted that, well, a reward or recognition in connection with his employment requires employment to be at least part of the reason for the outright payment, it would be anomalous if we could catch loans, i.e. where there's a right to an obligation to repay, with some lesser connection. And I refer back to what my lady and Lady Justice Falk said in London Luton about Parliament generally being presumed to taxpayers in similar situations in a similar way. And it would be very surprising if an outright payment was not caught under Part 7A because employment was not part of the reason. But the same payment with an obligation to repay attached now can be caught because there's some broader concept of in connection with that allows it to be caught. That's not taxing taxpayers in similar situations in a similar way.
Are they similar situations?
Well, if anything, the outright payment's a greater benefit. If the trust makes an outright payment to the employee, it's theirs. They can do what they like with it. They've received a benefit to the full value of the payment. If it's a loan, I accept that often an issue in these cases is it a genuine loan, but assume it is. There's an obligation to repay. And what's being said, or what the consequence is, well, the outright payment has to be a reward or recognition in connection with employment. It's only caught if it is. And that seems to require employment to be part of the reason. But if we attached an obligation to repay to exactly the same payment, so now you have to give it us back at some point, you've got less, because now you've just got money for a temporary period, but now it can be caught under Part 7A, because somehow there's a broader concept of in connection with. So the point is that a loan, at best, is the same as an outright payment from a tax perspective. At worst, is a lesser benefit. There is no reason to catch loans in circumstances where an outright payment would be caught. At the very least, you could treat them the same, which is essentially what this does, because when you get to the value of the relevant step, as we saw in Z2, I think it was, it's just the amount of the payment of the loan, and there's no relief when if you repay it. And that's probably to do with Parliament thinking, well, a lot of these cases there's no intention to repay the loan. Fine. But it's one thing to treat loans and outright payments in a similar way, the same way. It's a different thing to say, well, a loan's going to be treated in a different way to the disadvantage or to an increased taxation. You're going to catch loans where we wouldn't catch outright payments. So that's my point on that. It doesn't make sense to catch a lesser benefit when a greater benefit wouldn't be called. The third point at 44 of my skeleton is to note that it's not sufficient that the arrangement will provide loans that have a connection with the individual's employment. It must be shown that the arrangement was a means of providing or concerned with providing loans with that connection. And what an arrangement is a means of providing or concerned with providing is a question of what the purpose of the arrangement is. And therefore it's natural, given that we're looking at a test that does include consideration of what is this arrangement trying to do, to say that, well, the in connection with test is also looking at the reasons. They're both looking at the reasons. Because otherwise you'd end up with a situation where you identify a connection of some sort with employment, but when you get to is it a means of providing loans with that connection, well, you'd answer no, because it's no part of the reason. Bless you, lady. No part of the reason for providing the payment. And so I give an example of 46, where you declare a dividend in a sole owner manager company. It necessarily involves the provision of a benefit to a person who is an employee. But the dividend is not a means of providing benefits in connection with employment, if in this hypothesis there is a connection. So that requirement to look at what the arrangement is a means of providing or concerned with imports a question of, well, what's its purpose, what's it trying to do? Which makes it natural, we say, that when you're looking at the in connection with test, it's also concerned with the reasons.
But you focused in the second half of that paragraph on means of, but the statutory language is a means of providing or is otherwise concerned wholly or partly with the provision. Well, that appears to be very broad language.
But wholly or partly is explained by the fact that an arrangement can relate to more than one employee.
Yeah. We'll leave out the wholly or partly, but is otherwise concerned with.
Yes. The overall phrase, though, is still asking, what's this trying to do? What's it getting at? Which is made stronger still by the next point, which is the essence. We're always concerned here with the essence. And that's fourth point, which I think I've made several times and can take very briefly. And so, as I said, 50, a connection with the employment that is not part of the essence of the arrangement, because it is not essential, fundamental, or key to the arrangement, is not sufficient to bring it within condition C. And therefore, we're not concerned with connections to employment that are incidental or not important. And we say it's the reasons for the reward, recognition, or loan that will reveal its essence, as it was in Barclays. And that's, as I said, 52. Look at the opposite way. If the payment to the individual is being made entirely for reasons other than the individual's employment, it's very difficult to see how any alleged connection with the payment between employment and the employment is part of the essence.
But if this is all true, why didn't Parliament just say by reason of?
Because by reason of is already used, and I'm coming to this later, it's already used in another context in the legislation. And Parliament is concerned to make sure that there's no carry across of the perceived weakness in the from and test or the by reason test in terms of not catching payments to third parties. It's concerned not to carry that across to Part 7A.
So that would be made clear because this is all about third parties.
Well, I mean, Parliament doesn't want to have the debate about that, so it's not carried that across because it has its own meaning there, which may we're coming to this in a moment, may require more than simply being part of the reason. Maybe it's difficult to know. I'm sort of getting ahead of myself slightly. We know that the from employment test, and the by reason of employment test both pose questions of causation.
Yes.
they appear to be slightly different. It's difficult to say in what way they're different, and in many cases, in at least some cases, the analysis of one will provide the complete answer to the other. But what Parliament was concerned about, we submit, is, well, if we carry across those tests, are we importing the perceived baggage in terms of payments through third parties, which didn't want to do that. And so it uses the in connection with test.
Can I just ask you this? And I'm sorry if I'm taking things out of order.
fine,
Please come back to them. Okay, but can I just be clear? If your submission is correct and your submission was accepted by the FTT, is that a causation test?
Asking whether employment was part of the reason.
Yes.
I don't necessarily know entirely what baggage I might be accepted by saying it's a causation test, but it's certainly looking at the reasons, the causes of the payment, yes.
Right.
And that's my point. It exists on the same spectrum as the by reason of test and the from test, which is actually not surprising. Because why would Parliament, having set its mind on looking at the reasons of the payment, strike out in an entirely different direction? So we're no longer concerned with the reasons of the payment, we're also concerned with other things. If it was going to do that, we'd expect some signpost or indication as to what it had in mind. Why are these things where employment's no part of the reason caught? I can't give you an answer to that, although it wouldn't be part of my case. But equally, I respectfully submit that HMRC haven't, and the Upper Tribunal doesn't explain why employment's not part of the reason. Why does Parliament want to tax that as employment income? That's the difficulty in my submission with striking out in a different direction. And just to finish off the point on the essence, I've shown you Clipperton this morning, and that's a good example, we say, of looking at a similar scheme, payments that ultimately were held to be in respect of shares, and showing you what the substance was there. This court considered it obvious that Judge Morgan got it right there. 53 is we say it's consistent with the general nature of employment income, which is, I think, the point I was just making.
Yes.
Which is that at its core, there is an understood concept of, well, what is employment income? And obviously the detail is left to the legislation, but ultimately we can conceive of employment income as being income where employment is part of the reason. And that's why we say at 54, both the from test and the by reason test ask, why was the sum given to the individual? And I've given you authority for that. I've referred to Vermillion in the Supreme Court, which explicitly says that the by reason of test poses a question of causation.
Yes.
And I showed you by reference to Kuna this morning that they were talking there both in terms of a connection and a sufficiently substantial cause. So the general nature of the link that Parliament has in mind to employment is one that looks at the reasons. That's a consistent theme, we say, through these tests. And we say that when you get to Part 7A, Parliament didn't strike out in an entirely new direction. It's difficult to explain. It's on the same spectrum. And the point made at 56 by reference to Wilcock and Even is that in the general earnings charge, you've got the from employment test. Then we have the benefits code with the by reason test. And in many cases, it's difficult to see the difference between them. And you can see Mr. Justice Carnworth in Wilcock and Eve making that point. I don't propose to take you to it. It's at 253, but I've got the quote there. In any event, on the facts of this case, I cannot see any basis for reaching a different decision under Section 61 from that under 181. Commissioners clearly have both in mind. Found the payment was not linked to the employment during the year assessment, and therefore not by reason of employment. Recognise the link with the loss of the benefit of the share option scheme. It seems to me that if a distinct factor for the purposes of Schedule E test as held by the House of Lords in Aberdeenville, then the same will apply to 61. As I say, it's at 57. That doesn't mean they're exactly the same tests, but it does mean they exist on the same spectrum and they require essentially the same analysis. You've got to look at the reasons. Why was this payment made?
I don't understand that, I'm afraid. I'm sure it's my fault, but if they're not the same test, why is the same analysis required?
because you've got to look at the background for and reasons for the payment. That was the point being made by this FTT and in Kuna, that you've got to look at the reasons for the payment.
Yeah.
And it may be that it needs to be a stronger reason, a sufficiently substantial reason to be from employment, that something less than that might suffice for the by reason test. So you can look at the reasons, and once you've identified your reasons, you might say, well, employment is part of the reason, but it's not a sufficiently substantial reason to satisfy the from test. But it may satisfy the by reason test, and it would satisfy the part of the reason test. So on the same spectrum in terms of looking at the reasons, but you can set your threshold differently along that spectrum.
Thank you.
And 59, I make the point I think we've already seen in the FTT decision, which quotes
Yes.
that, frankly, when the courts are talking about the from test, they slip in and out of talking about a relevant connection. It's
Yes.
not actually a fundamentally different test, and you can explain them both in terms of each other.
I speaking for myself, I regard Lord Justice Mummery and anything he says as deserving the greatest respect. He was a great judge, in my humble opinion.
Yes.
But nothing that judges say in judgments should be read as if it was in a statute.
Of course. And we saw in Kuna, the court said, well, we mustn't place a gloss on it, but some gloss is inevitable. And then they went to explain sufficiently substantial cause or sufficiently substantial reason, and that's taken forward and properly applied. I mean, there's a little bit of tension there, but it hasn't concerned anyone. And in our context, we know from multiple cases that we do need to give content to our test of in connection with. It's not a case of you can just say, well, in connection with means in connection with, because we know from the multiple cases it can describe a range of links, and what type of link and what strength of link will depend upon the context and the background. So inevitably, we're going to have to get into the questions we've been looking at. I make a point in passing at 60, because one of the difficulties we've had with the appellant throughout this is understanding what exactly HMRC say the correct approach is. I think the closest they came is in reply in the Upper Tribunal. And that's a quote there where Mr. Ghosh said, I say that what it's looking at is whether the directorship explains the law. We simply made the observation that seems to be not very different, at all different from what we're saying. At 62, I've already taken you to Barclays Bank. I won't take you back there, but we do note that there the connection was in terms of reason for selection. The reason why those payments were connected with employment is because the reason for selection was as a recipient of the free tax benefit, and the reason for selection for that was the employment. And then at 63, I think this is a point I was making in response to my Lord's question earlier, which is, let's say this is wrong, and we've got a broader test on our hands. It's striking out in a new direction because it's not the same as, it's quite different to the by reason test or the from test. What criteria, what basis are we now going to apply, keeping in mind London Luton, keeping in mind Barclays Bank, to identify what is or is not a sufficient connection? What are we looking for here? What is the justification for bringing things within our in connection with test? As I've said many times, we can't see any basis for that. The fourth point begins at 64.
Yes.
And it is logically correct that the inevitable consequence of interpreting Part 7a such that it can apply where employment is no part of the reason is that it will apply, does apply to payments that are made entirely for non-employment related reasons. And it means that a distribution which is paid only for the reason of providing a shareholder with a return on its investment is, or could be, in connection with employment. In fact, as we say, those are the circumstances in this case, and they appear to be the circumstances of the Clipperton case. Now we say at 67, if the legislation compelled that result, well, we'd have no choice. But it doesn't. It uses a phrase that Parliament must know the court is going to give content to. And we say it offends basic principles of income tax to say that a payment, to interpret this phrase and give content to it in such a way that payment where employment is no part of the reason is nevertheless to be taxed as employment income. And we quote from PA Holdings in 67, it's page 292, but the quote is there, and it's a simple point that Lord Justice Moses made, but an important point. I've underlined it because Lord Justice Moses said at 58, it's inconceivable that the introduction of a new schedule, let alone a new subsection, dramatically changed the structure for charging income tax. Each schedule remains dominant over its own subject matter. And we do say that has some relevance here, because if we have a payment by the company that is, in substance, C clip it and see this case, a distribution respective shares, it would be a significant, dramatic change the structure of the Income Tax Act to say, well, then what is done with that payment by the trustee is employment taxation. That is a very significant change, and if we were forced to that conclusion, if we could see a justification for it, that would be one thing, but there's none. So say at 69, in connection with tests, it's not a deeming provision. Parliament has instead repeatedly instructed the court and the revenue and indeed taxpayers to get to the essence of the matter. And if the essence of the matter is that this sum represents a distribution of the company's profits to its shareholder, employment being no part of the reason, there is no reason for Part 7A to apply. Paragraph 70 is a point I've made, I think, several times. No sensible basis for any other test. I think I've made all those points. I don't think I need to refresh them. Point of 73 perhaps is important, which is that is legal certainty, because it shouldn't be the case that every time you want to find out there's a connection or what, you need to go after the courts and tribunals and ask them. This has to be a test that's operable by the revenue, by the taxpayers in completing the returns and checking the returns. And if we just say, well, in connection with means any connection, without any bar or guidance as to how we decide whether it's a sufficient connection, we're going to be in a very difficult position, both as taxpayers and the revenue, to work out, well, is this particular payment, well, nobody's going to know. You're going to have to go to tribunal every time, and they will apply what is an extremely vague test. In fact, so vague and uncertain, it's difficult to see how it can perform its function as legislation.
Yes. Should we look at the Himati case?
I wasn't proposing to. This is simply a broad point about certainty.
Do you mind if I would like to be reminded of it?
Oh, of course, my
I
lord.
would just like to have a quick look at that passage.
Of course, my lord.
Where do we find that? Excuse me.
Page 566.
Thank you.
Should be bundle 2.
Yeah.
And this concerned whether the provisions in relation to detaining asylum seekers were sufficiently in accordance with law.
Right. So does this arise in the context of the Human Rights Act? Is that the point? Is that in accordance with law?
No, it was in the context of Brussels regulations relating to the detention of asylum
I see.
seekers.
Right. And it's paragraph 70, is it?
Yes.
Yeah. Oh, yes. Thank you. Yes. In fact, yeah, Lord Kitchen is using it there in the context of the ECHR.
Well, there is a group of cases from the European Court of Human Rights that talks about the meaning of law, and the Supreme Court said, well, yes, that's very interesting in relation to that area, but here we're dealing with the detention of asylum seekers under the Brussels regulations, and they apply a slightly stricter approach to the law.
Yes.
It's my point for present purposes is not that you are required to interpret the meaning of law. It's a far too big a task for this case. It's simply that when you're analysing and deciding what in connection with means, you should bear in mind the functional and consequences and the effect for certainty that whether taxpayers and the revenue will be able to apply and know some degree of confidence what the outcome of a particular set of facts is.
Yes, thank you.
And that's, as I said, it's a response to what we perceive to be the lack of explanation and justification for a broader test. Our test is at least understandable and capable of being applied, and it fits with all the other points. Unless the tribunal has questions on what I would say is our positive case, then I propose to turn to the Upper Tribunal's decision, which takes a different approach.
Thank you.
We can see that at 74. And I've shown you these points this morning when we went through the Upper Tribunal decision. The Upper Tribunal made 2 points to reject the part of the reason test. It said, what first, it's necessary to construe Part 7A in accordance with its terms and purpose. Not possible to limit it to particular schemes involving redirection of earnings. And 2, Parliament has chosen in connection with tests rather than the time honoured from employment or by reason tests.
Yes.
And we've got a number of respectful responses to that. First, we respectfully point out that despite the Upper Tribunal saying it was necessary to construe Part 7A in accordance with the purpose, the Upper Tribunal fails to identify any purpose that means or leads to the conclusion that Parliament intended to tax payments which employment was no part of the reason. So, on the one hand, the Tribunal says, yes, we must interpret this in accordance with purpose, but we reject a test where employment has to be part of the reason. But it doesn't then explain how that fits with a purpose, which also then undermines how you apply that in practice, because we don't know. And you can see there's a possible misstatement of the purpose, or incomplete statement of the purpose, which we've quoted at 77, taken from 146. The purpose is to tax as employment income payments provided through third parties. Well, it's not quite that. It's fundamentally and critically dependent upon the employment connection. The second point we make is what we perceive as the oddity or potential oddity of the Upper Tribunal saying, well, yes, it must be a strong and direct connection. That was the Upper Tribunal's test. But it's quite odd to say, well, that's what Parliament intended, but equally, employment doesn't have to be any part of the reason. It's difficult to see how you can have a strong and direct connection, we say, where employment is found not to be any part of the reason. Third point I think I've made several times.
Just a small point. I hope it's not being pernickety, but it interested me that at paragraph 146, the Upper Tribunal didn't actually say strong and direct, but said strong or direct. Is there any significance in that on your submission?
And then we go to 150 where they apply their test.
Yes.
It says sufficiently direct and close connection.
Yes, that's true. Yes.
To be honest, I'm not sure. It's made slightly more difficult by the fact that neither party asked for this test. I think the Upper Tribunal thought it was aligning itself in some way with London Luton. You can see that at the end of 146.
146.
It says, in fact, in the last sentence, strong and close.
Yes, so we're seeing 3 different adjectives now: strong, close, and direct.
Yes.
2
Yes.
of which may suffice.
Yes, I mean, this is possibly one of the perils of going off in a direction not submitted for the parties. I can't add to that. It's not my test. I didn't submit for it.
We'll wait to hear what the revenue say about it. Okay. Right, I took you out of turn. Sorry. Do you want to go back to your skeleton?
Yes, I think I made the point at paragraph 80. I won't repeat it. Paragraph 81, we say obvious for all the reasons set out above what the purpose was. And so we do have a clear understanding of what the purpose was. I'm certainly not saying it is limited to targeting a particular scheme. That's not what I'm saying. That's not what the background materials show. What I do use the Rangers case for is simply to show you the type of problem Parliament had in mind, whereby somehow routing it through a third party. That's the only relevance of that particular scheme. paragraph 82, I've already made this point. So the Upper Tribunal says, well, why didn't Parliament just use the from employment test or the by reason of test? And we say that, well, that's explicable by potential concerns that those tests could be argued not to catch payments through third parties or have difficulties catching such payments. And it's the sixth point at 84. Casting a wider net from employment or by reason does not mean intending to catch payments for which employment is no part of the purpose. I've made that point many times.
Yes.
It's notable, we say, that the example at 145 it still seems to be in terms of the reasons for the payment. So our overall submission, we've got our positive submissions, that's why we say that is the right test, and with respect, we submit that the Upper Tribunal doesn't have a sufficient justification for its own test. Unless the court has any questions on ground 1, I propose to move to ground 2. The situation that ground 2 considers is that the tribunal has identified a connection, a relevant connection. We say, on the authority of Barclays Bank, that it's necessary to consider whether that connection is displaced in the circumstance of the case, and we respectfully submit that there's no point at which we see the Upper Tribunal considering this question. I've already made the point when I was going through Barclays that with respect the Upper Tribunal seems to misunderstand what Barclays is saying. So that paragraph 88, I refer to the Upper Tribunal at 131. If we could look please at 131 of the Upper Tribunal decision. It's on page 104 of the core bundle. See in the fourth subparagraph, which is intended to be a proposition drawn from Barclays and London Luton, that a connection once established is unlikely to be displaced by other factors or connections. It's actually paragraphs 21 and 22 of Barclays, and as I think I made this point as strong as I could this morning, what is being said there is not that any connection cannot be displaced, but a connection by reason, based on the reason for selection, cannot be displaced. If it's helpful, we can go back to Barclays to look at that point again. It's page 273. Which will be in the first one. The points are made 3 times, I would submit. 21 and 273. First sentence, Mr. Peacock emphasises that although the recipients or claimants were chosen,
Yes.
So paragraph 21 and 273. Although the recipients were chosen because of their connection with the pension scheme, their status, so that status of having been chosen, for that reason is simply one of the relevant surrounding circumstances. But in my judgment, once that status is shown, it is rare to find that its connection is displaced. Similarly, at the beginning of 22, it's difficult to think of a case where a benefit made available to a person chosen for their connection is not given in connection with their service. And then at the bottom of 273, 3 lines up at the very end, it demonstrates that once recipients have been chosen by the employer or trustee of the scheme for their connection, the presence of that link is unlikely to be lost. So my submission is that these paragraphs 21 and 22 are emphasizing that a connection based on being chosen because of the employment is unlikely to be displaced. They are not authority for a much broader proposition that any connection with employment once identified is unlikely to be displaced. That is not what the Court of Appeal is saying. which means that in turn I respectfully submit that paragraph 131.4 misstates the appropriate principle to be derived from Barclays Bank, and that then explains why the tribunal, this upper tribunal, does not consider whether the connection it purports to identify is displaced on the facts of this case. And we say at 91 that the upper tribunal carried through this error to its own application of the test at 150, where it failed to consider whether the connection was displaced.
I also noticed, forgive me again for interrupting you, at paragraph 131, subparagraph 2, the upper tribunal, in summarising the earlier two authorities, said that a connection can be both direct or indirect.
Yes.
But then later on, as we've seen, they appear in this context to use only a direct criteria. Have I misunderstood?
It's difficult for me to speak for the upper tribunal. And my lord's already noted that sometimes they say strong or close, strong or direct. Sometimes they say strong and close. It's maybe that's what they mean.
Right.
For my part, I can't take it further than that.
Thank you.
Well, the authorities you've shown us speak of the
Yeah.
possibility of a direct connection or alternatively an indirect connection.
And in Barclays Bank, the free tax benefit was provided in connection with employment, and therefore the payment and substitution for it was in connection. I'm going to disagree.
Yeah.
But I mean, the test becomes even more difficult to sort of circumscribe or apply if now it's strong or direct or close. We've got three possibilities. We don't know why one connection might be stronger than another or closer than another, or where the appropriate threshold is. It becomes very difficult to apply. And we would submit that going back to my displacement point, that any connection that the upper tribunal has identified is displaced, but ultimately that needs to be remitted to the tribunal to be dealt with. It should be. And I've already referred you to Clipperton, which we say is helpful here, because clearly there the Court of Appeal, and indeed the same tribunal, Judge Morgan, found that the connection with the shareholding was the clear and fundamental connection there. There's no reason why that wouldn't displace whatever connection the upper tribunal thinks it might have found with employment. Unless there's any questions on that aspect, I move to ground 3. This is the upper tribunal's decision on its own test. Of course, this doesn't really arise if the court says, well, that's not the right test. But if it is the right test, then we address it in these terms, and we respectfully submit there are a number of errors, which we summarize at 93.1. First is failing to put the question in its full factual context, and therefore to consider all the relevant facts. Second, failing to consider or explain why the proposed connection was a connection in the first place. And we observe it's difficult to test the strength or directness or closeness of a connection without understanding why it's a connection. For example, if you say, well, the connection we've identified as it's part of the reason, well, you can test how strong a part of the reason it is. If you just say, well, this is a connection, but we can't tell you what type of connection it is, how do you assess how strong that is? It's very difficult. I mean, at least if there are other types of connection, you have to at least identify what type of connection you've identified to see how strong it is on whatever spectrum or whatever concept you're relying upon. And that's why I say the reason, as I said, you can assess how strong a reason it is. With the tribunal's approach, you can't. And then we respectfully submit at 3, there was an error in deciding there was a direct connection and deciding there was a strong connection. At 94, we summarize various aspects of the facts which I've taken you through this morning. And we say that once those facts are properly considered, well, first of all, the upper tribunal doesn't, we say, properly address them at all. And once they're considered, they point in the opposite direction, the tribunal's conclusion. It's very difficult, we say, to unpack and understand what is being said at paragraph 150. There's a slight irony that the Upper Tribunal says that the FTT's reasoning on Part 7A was compressed, but then paragraph 150, we've got a very compressed application of the Upper Tribunal's own test. And if we look, please, at 150, if we did look at it this morning, we need to try and understand now what is being said here. And the point is, the amounts paid into the trust reflected the profits of the dental practice. That was carried on by the appellant. Dr. Thomas was actively engaged in the practice of the dentist, assisted by hygienist and associate dentist. All material times he was the sole director and therefore guiding mind, responsible for the conduct and direction of the business. That is a sufficiently direct and close connection test. Well, with respect, we've asserted a couple of facts there. One, that the business was carried on, and Dr. Thomas was part of carrying it on, and two, the profits arose in that business. But how does that move us into the strong and direct connection test? There seems to be a gap in the logic there. And as we say at 95, the reasoning seems to lead to odd results. The essential reasoning is, well, because you, Dr. Thomas, as director, ran the business that produced the profits, that is a direct and strong link. But if that logic holds, then anything that the company did with that profit would have had a direct and strong link with Dr. Thomas's employment. So if the company decided to make a donation to charity, that, on the Upper Tribunal's reasoning, would have a direct and that donation to charity would have a direct and strong link with Dr. Thomas's employment, which seems to be, in our respectful submission, wrong.
Would that fall within the terms of the charging section?
Sorry, a payment.
If you donated money to a charity, put it in a bank account to earn interest or reinvest it in the business, each of those three examples you give, are they otherwise caught by Part 7A?
Well, they technically don't involve a relevant third person, so you don't have the payment to the third person instead. But so I don't know. The direct payment to the charity by the company wouldn't be caught.
No. So how is this example helping us?
Because we're testing whether it makes sense, putting to one side whether it leads to a charge or not. Does it make sense to say that donation to the charity is in connection with Dr. Thomas's employment? Just to test the logic underlying this, not because it in that example leads to a charge, but does it make sense as a logical proposition?
I see.
So it goes no further than that, my lord. I mean, there is an example in the moment. For example, if you have a joint venture company owned by two other companies, 50-50 shareholders in a joint venture. On the Upper Tribunal's logic, the joint venture company pays dividends up to the two 50-50 shareholder companies. That's a payment to third parties. When they then use that money to pay out dividends, those payments are caught by Part 7A because, in this hypothesis, the person was involved in the running of the business. It just leads to connections where nobody would expect to find a connection or a charge to employment tax. That's our point. And the point we're essentially making here is that the particular use made of the money by the company doesn't have a direct and close connection with how the money rose to the company. And in fact, as I pointed out when we went through the Upper Tribunal decision, the Upper Tribunal seems to make a similar point at 118. If I could just take you back there. Okay, this is page 101. Mr. Ghosh's submission of the payments by MDPL to the trust represented the fruits of Dr. Thomas's labour does not lead to the conclusion that payments constitute earnings on general principles. The source of the income arising to the payer does not mean that the payments by the payer have the same character. For example, if the company with a sole shareholder earns rental income, the onward payment does not have the same character. And we say that's correct, but it seems like the 150 is saying something that's in tension with that, because it's saying, well, let's look at how the money arose to the company, arose through a business in which you were involved and you were as director in charge of. You're looking at the reasons why the money arose to the company and then attributing that as a strong and direct link to things done with that money by the company. We say that's the same error of logic that's noted at 118. We certainly say it's difficult to see how that's a direct connection, given that step one, the money arises to the company. Step two, the company has a decision as to what to do with the money. It seems to be an indirect connection at best. Paragraph 100, please, which is that whilst Dr. Thomas was, of course, paragraph 100, my skeleton, I apologise.
Yes.
Whilst we accept that Dr. Thomas was, of course, director of the company, there's no examination or explanation by the Upper Tribunal of what that amounted to in practice that leads to the finding of a strong connection. What did Dr. Thomas actually do that leads to this conclusion? Or is it the fact that he was legally responsible for the business as a director of the company? But that can't be right. And there is a lingering sense, as we said, 103, that whatever force the facts identified or purportedly identified by the Upper Tribunal at 150 have, whatever force they have, is solely as potential indicators of the reason for the payment. That seems to be, as far as we can tell, why they might have any force. But that's not open to the Upper Tribunal. The FTT's made its findings of fact, and it's found to the contrary. There's nothing the Upper Tribunal is able to explain to us that dispels that sense. It doesn't give us any explanation of, well, why is this a connection, and why is it a strong and direct connection? Here are some facts, or alleged facts, and here's the answer very shortly after that it's a strong and direct connection. At 106 and 107, I deal with examples, including the example I've just given to the court as to where this approach does lead to problems. I mean, it's logically we say suspect of wrong, but the broader problems are identified here, because on this logic, the undifferentiated profit of a company arising from the work of a number of people always has a strong and direct connection with the employment of the director. And so any dividend always, or any dividend out of those profits always has that strong and direct connection. But we say that can't be what Parliament intended. And whilst, as I accept in a straightforward case where you've got a payment of a dividend from the company to the shareholder, Part 7A wouldn't be engaged because you've got no relevant third party. The example I gave of a joint venture company owned 50-50 by two other companies, where the dividends go up to the first two companies and then out. In those situations, the two 50-50 shareholders would be relevant third persons because they're not the company itself, they're not in the group of the company, so they would be relevant third persons. They are making payments to the shareholders / directors of the company, the bottom company, and therefore that is caught on the Upper Tribunal's test. A straightforward dividend in that situation would be caught. And so we say overall, properly considered, and this is 108, the only sustainable, strong and direct connection on the undisturbed findings of fact by the FTT was the shareholding. And in other cases, if the taxpayer doesn't succeed in discharging the burden of proving that employment was not part of the reason, different conclusions will be reached. But in this case, we did discharge that burden before the FTT, and we said the consequence follows. Ground 4.
Yes.
I've touched on this a few times, so I'll take it swiftly. The essence of the issue is that the arrangement has to be a means of or concern with providing benefits or payments with the identified connection. And we submitted 111 that what arrangement is a means of or concern with doing is a question of purpose. What's it trying to do?
Objectively construed, because we know from the statute it's an objective test, don't we? So not to be confused with purpose in other contexts.
Yes. And the Upper Tribunal notes our submission on this point, but with respect fails to address it. And we said that if it had done so, it would have concluded, we said 114, that it was no part of the reason for this arrangement. In light of the findings, it was no part of the reason. You can't then say, well, it's part of what this arrangement is concerned with or trying to do.
Forgive me, Mr. Phil, does ground 4 add anything to ground 1? If you're right on ground one, you've won.
Yes.
If you're wrong on ground one, what aren't you begging the question? You're assuming here that you're looking for
No,
purpose.
because the FTT's findings as to the application of its test, that it wasn't part of the reason, is solid. And so if I'm wrong and the in connection with test does look more broadly at other connections, so the in connection with test is satisfied in some other way, we still have to ask the question whether this arrangement was a means of providing rewards with that connection. Is that what it was trying to do? And at that point, again, you're asking the question, well, what are the reasons for this? What is it trying to do? And so I think it does add something in that situation. If it has to be part of the reason in the first place and it's part of the in connection with the test, then we've probably answered the question at that point, because that will carry through. But if we are looking at other types of connection, I submit it does have an extra limb to it at this stage. And testing that conclusion, well, I showed you 169 and 171 of the Upper Tribunal's own conclusions, where they say this has got nothing to do with the trade or benefiting the trade. And so in those circumstances, how can you say, well, on the one hand, this has got nothing to do with the trade or benefiting the trade. It's all to do simply with extracting the profits to Dr. Thomas and getting a deduction. How can you then say, well, it's part of the essence of this arrangement to provide loans with a connection to employment?
Isn't there thinking that this was a tax avoidance scheme and didn't work? So if you've made a mess of things in trying to execute an effective tax avoidance scheme, then why can't both propositions hold at the same time?
Well, I understand the sort of primitive urge to make sure things, or to say it doesn't work, but it was accepted it didn't work. The question was, how did it not work? And you can see from Clipperton that, there they were trying to avoid tax on dividends. It said, well, but it didn't work. It was a distribution in respect of shares it got taxed. The question for this tribunal, the first day tribunal, was, was this to do with employment? Answer, no. And essentially that's what this was. This was in substance the same as Clipperton. It was an attempt to extract the profits of the company to the shareholder without a charge tax and also get a deduction. Except that it didn't work. Our key point is, well, that doesn't mean it's now taxable as employment income. We're not in a worse position because we tried a tax scheme, certainly in terms of the basic tax charges, other points aside. It doesn't become employment income just because you've tried to do something that a failed tax avoidance scheme. But yes, there is a sense that, well, this doesn't work, and Part 7A is designed to catch tax avoidance schemes, and therefore this must be within Part 7A, but Part 7A is not designed to catch every tax avoidance scheme. It's about avoiding employment tax, and we've been through all the materials that show you that there are other mechanisms and ways of dealing with attempts to avoid distribution tax and similar. Clipperton shows you that. So the fact that it's a failed tax avoidance scheme doesn't mean it's employment income. Unless the court has any questions on my submissions, I propose to hand over to Mr. Blades to briefly address you on the corporation tax issue.
No, thank you very much. Yes, Mr. Blades.
Thank you. I intend to be fairly brief with ground 5.
Thank you.
So ground 5 is set out at paragraphs 117 to 122 of our Skeleton argument. And as you'll have seen, we refer to this as a potential ground of appeal. That's paragraph 16 of the Skeleton argument. Potential because it only arises if we're wrong on our primary case. So as you've heard, the appellant's primary position is that the payments have no relevant connection with Dr. Thomas's employment. And it follows, we say that there's no entitlement to a corporation tax deduction. So why is this relevant? Well, you've heard our case on ground 4 is that the Upper Tribunal needed to be able to conclude that the essence of what the arrangement was seeking to achieve was to provide loans with the identified connection to employment. In other words, for the Part 7A charge to arise, the Upper Tribunal needed to be able to conclude that the purpose of the arrangement was to provide loans with a connection to the employment. Now, it's not apparent that the Upper Tribunal considered that way of phrasing the test, and we say even if it did, it wasn't open to the Upper Tribunal to conclude that a purpose was to provide a reward for employment. And that's because of the FTT's findings, which Mr. Firth showed you earlier. If, however, contrary to our primary case, the Upper Tribunal did consider the point, and did, contrary to the FTT's findings of fact, permissibly conclude that the arrangements did have the purpose of providing loans in connection with the employment, then we say a corporation tax deduction must be available. The relevant legislative provisions are Section 74 of ICTA, and for the later period, Section 54 of the CTA 2009. I don't intend to show you those, but for your note, they're at pages 5 and 115 of the authorities bundle. And the question posed by those provisions is whether expenditure is wholly and exclusively for the purposes of the trade. And we say that boils down to two questions here. The first is, was there a trade benefit purpose at all? And the second is, was that purpose nevertheless insufficient because obtaining a corporation tax deduction was itself an end? So those are the two questions that we're concerned with. And if we can start with the Upper Tribunal's decision, and its decision in this regard is short. It's dealt with really in 3 paragraphs. This is page 111 of the core bundle.
Yes.
And the analysis is really in paragraphs 169 to 171.
Yes.
So as I said, there's 2 questions here. So I'm going to take them in order. Was there a trade benefit purpose? So starting at 169, we can see that the Upper Tribunal begins with that question. And you can see that the Upper Tribunal concludes that the purpose of the arrangement was to empty MDPL of profits and to get those profits into the hands of Dr. Thomas through non-taxable loans.
Yes.
And then down to 171, we see the same point. At the end of the first line, the intention of MDPL in making the contributions was to empty the company of profit in order to fund a tax-free benefit, i.e. the loans to Dr. Thomas. There was no trading purpose and no benefit to MDPL's trade.
Yes.
We agree. In short, we agree with that. There was no intention to reward Dr. Thomas for his services. And the effect of that is that the arrangement was not a means of providing loans in connection with his employment. The loans had nothing to do with his employment. The result is that the corporation tax charge is not available, but nor can there be a Part 7A charge. Further, it would have been an error of law for the Upper Tribunal to have reached a different factual conclusion. The FTT's findings of fact made it clear that the purpose of the arrangement had nothing to do with Dr. Thomas's employment. And as we saw earlier, that was paragraphs in particular 129 and 139 of the FTT's decision. Ground 5 only arises if we're wrong on those points. In other words, it only arises if the Upper Tribunal did make a finding of fact that the essence of what the arrangement was a means of was to provide loans with a strong and direct connection to the employment, and it only arises if that was a permissible finding for the Upper Tribunal to have made. If that is the case, though, if we are wrong on those 2 points, and the Upper Tribunal did permissibly make this finding a fact, then it follows that a corporation tax deduction must be available. It's contradictory to say that the purpose of the arrangement was to provide loans with a strong and direct connection to Dr. Thomas's employment, but to say that there was no trade benefit purpose.
I don't understand that, I'm afraid. Why is it not perfectly logical that the purpose was to benefit Dr. Thomas, not to benefit the trade?
Well, it's not enough for it just to be to benefit Dr. Thomas. It has to be in connection with his...
We've been through all of that. Like, those are grounds 1 to 4.
Yes.
Right? Ground 5 only arises, as you say, if we reject grounds 1 to 4. On that hypothesis, why should we accept that there was any purpose which would benefit the trade of the company as opposed to Dr. Thomas?
Well, our position is, if we've lost on ground 4, well, if we've lost on the Part 7A charge, that must be because it's been found that the purpose of the arrangement was to reward Dr. Thomas in his capacity as a director. And we say
connected with his employment, but it's a different test on Section 74, isn't it? What you're asking is whether the payment by the company was wholly and exclusively for the purposes of its trade. Different test.
I accept it's not the same test, but we say that it's...
You say it's axiomatic.
It's odd to divorce the 2 propositions.
Right.
We say expenditure with a purpose that has a direct and strong connection with the employment also has a direct and strong connection with the trade. If it's to benefit the employment, then it's to benefit the trade. So that's how ground...
Sorry, I really don't understand that. I mean, however artificial it is, this was a company, and that's the entity which was going to have its that was the company that was trading, and so it's what's wholly and exclusively for the benefit of the company. Whether it's Dr. Thomas's remuneration as a director has got nothing to do with that, has it?
Well, a payment made to reward an employee is fairly well trodden that would have the sufficient trade benefit purpose. So if what has been found on grounds 1 to 4 is tantamount to saying the purpose was to reward Dr. Thomas, then that would, we say, have the trade benefit purpose. So that's how ground 5 fits in with the appellant's case. And that's why we say if we get to ground 5 at all, then there must be a trade benefit purpose. And what that leaves is just the second question, which is, was obtaining a corporation tax deduction an end in itself, or was it merely incidental? And just to show you the relevance of that question, if we could turn up the end of Lord Justice Millett's decision in Vodafone, it's page 265 of the authorities bundle.
Sorry, which page?
265. It's just 3 lines I want to show you next to the letter B. The sentence starting, but this is merely a consequential. ... So you can see that the distinction being drawn is between effects and purposes. And the question posed by the legislation here is, was it a purpose? An incidental effect is not enough. So if it was merely an incidental effect that you get the corporation tax deduction, that's okay. If it was a purpose in and of itself, then that would preclude deductibility of the expenditure. So that's the question that the Upper Tribunal has to address. Was obtaining the corporation tax deduction an incidental effect, or was it a purpose? And we can see what the Upper Tribunal says about that at 170, which is page 111 of the core bundle. And it's I want to start 6 lines up from the bottom of that paragraph. The sentence starting, a deduction for those sums. Let's say a deduction for those sums cannot, using the words of Scott's Atlantic at 67, simply be regarded as an ordinary, intended or realistically expected outcome of making salary, bonus or equivalent payments. And Judge Morgan's holding otherwise, in our view, constitutes an error of law. And then we see the same point in 171 in the final sentence there. We agree with Mr. Woodman that the purpose of MDPL in making these payments was to achieve a tax avoidance purpose for the benefit of Dr. Thomas, an MDPL, and was an end in itself. So they're saying the test is, was it incidental, was it a purpose? We think it was a purpose. And the simple point we make in response to that is that wasn't a finding open to the Upper Tribunal.
Just before you proceed, so on the face of it, that seems like a conclusion of fact. So you could challenge it on the basis of Edwards and Bairstow,
Precisely.
or you could challenge it on the basis that they erred in law. Now, they had found that the FTT did err in law, but you're not making that submission to us that they erred in law. Are you simply saying that it was not reasonably open to the Upper Tribunal?
I'm saying it wasn't open because it would have required an Edwards and Bairstow challenge, and no such challenge was made.
I see.
Nor was it made out by the Upper Tribunal that such a challenge would succeed. And I do want to just take you through the authorities that establish that it's a question of fact. And then I want to show you the FTT's findings, because I think those are what I need to show you to make good the point that this wasn't open to the Upper Tribunal. So the first case I want to show you is AD Bly Groundworks, and that starts at page 864, which I think must be volume 3 of your authority.
Sorry, which page again?
864.
Sounds right.
Where's my volume 2?
So apologies.
Yep. 2.
So 864 is the page on which the case starts. I want to. So this was a case about deductibility of contributions into a retirement benefit scheme. And I want to start on page 871, which I hope is still in the same volume, and it's paragraph 16. This is the FTT's finding. You can see in the quoted.
I'm sorry, which page are we on?
We're on 871.
Thank you. And paragraph.
So it's the extract quoted below paragraph 16.
Thank you. All right, and then
If you wouldn't mind reading that quoted passage. So that's the finding of fact, and then at the bottom of the page you get another quoted passage, and that's the conclusion that the FTT reaches. And so the appellant seeks to challenge that conclusion in the Upper Tribunal in this case. And if we turn forward to 875, I want to show you two of the grounds of challenge, and I want to show you how the Upper Tribunal dealt with those grounds. So the first is paragraph 30. You see Mr. Thornhill saying, in Scots Atlantic it was found at 67 that the taxpayer had an all-pervading object of reducing its corporation tax liability by whatever means possible. And the FTT in this case erred because it should have considered whether there was a similar all-pervading purpose. Then at 31 they say we reject that argument. They go on to give 4 reasons why they reject that argument, and I think the last 2 are particularly enlightening. So just below D, you see, thirdly, in any event, the FTT found that the primary purpose of the appellants was to reduce their liability to tax without incurring expenditure. And then fourthly, given the fact-sensitive nature of the inquiry, the FTT was right not to embark on a comparison of the facts in other cases. So that's the FTT emphasising that it's a fact, it's a question of fact. And interestingly, they also note that there's nothing to be gained by comparing the facts of one case to the facts of another case. And I say that's interesting because you'll have seen from the revenue skeleton in this case that they place reliance on the findings made by the FTT in another decision called strategic branding. And our response to that is, well, so what? That may have been the findings in that case, they weren't the findings in this case. So then the second ground I want to show you, the second ground of challenge in this case is at paragraph 33, and you can see Mr. Thornhill says the FTT was influenced by a number of irrelevant factors, and the Upper Tribunal deals with that at 34 onwards. This is all very helpful. These 34 to 36 is very helpful, I say. So they say, we raised with Mr. Thornhill the question of whether this argument fell within his grounds of appeal, given that permission to rely on equities and bare state grounds had explicitly been refused. Mr. Thornhill argued that on proper construction of the grounds permission was granted. We think it's likely that it wasn't. Then at paragraph 35, the Upper Tribunal reminds itself that it's only concerned with questions of law, and it quotes the well-known words of Lord Justice Evans in Georgiou over the page. This is an important extract because this shows what the appellant has to do if it wants to make good an Edwards and Bairstow challenge. It has to identify the evidence, has to identify the finding that it says is challenged, has to show that was significant, has to identify the evidence which was relevant, and it has to show that the finding on the basis of that evidence was one which the tribunal was not entitled to make. What is not permitted is a roving selection of evidence coupled with a general assertion that the tribunal's conclusion was against the weight of the evidence. And then at paragraph 36, it dismisses the factual challenge on the basis that it does exactly what Lord Justice Evans says you can't do. So that's A.D. Bly, that's everything I wanted to show you in that case. The second case is Scots Atlantic, and that starts at page 467. I think that must be volume 2 of your hard copy bundles.
So page 467.
467 is page 1. And this case concerned deductibility of contributions to an EBT. And the first point I want to show you is page 472. And it's the FTT's findings of fact. And it's just below paragraph 14. So you can see, in the case of both SAML and SFML, all the claimed expense had the purpose, alongside any purpose of remunerating directors and employees, of ousting the application of Schedule 24, and that dual, all-pervading objective of achieving a corporation tax deduction meant that none of the claimed expense was incurred wholly and exclusively for the purposes of the trade. So that's that question of duality of purposes arising in exactly the same context as it does in this case. The Upper Tribunal deals with deductibility at 44 onwards, which is page 479. You can see at 44 they say, our conclusion in relation to Schedule 24 makes it unnecessary to determine the appeals in relation to the application of Section 74. So it's over to that. But it does deal with it in some detail. And starting at 46, we see the key passage. You can see it's said by Mr. Thornhill that the contributions did not fall to be disallowed by this provision. The purpose and only purpose of the contributions was to provide benefits for employees through the EBTs. It is said by Mr. Coleman that the FTT correctly held that there was another purpose, namely to secure a tax deduction. He submits that not only was securing this deduction the purpose of the scheme, but it was also a purpose of the expenditure. So that's the challenge. Then over the page on 48, we see the Upper Tribunal remind itself that the taxpayer's object is a question of fact. And it's only, and this is next to B, it's only if its finding is one which no reasonable tribunal could have reached that it may be disturbed on appeal as a point of law. And then at 50, first, a taxpayer's object in making the expenditure has to be found. You have to look into the taxpayer's mind at the moment when the expenditure is made, and they cite Mullally and Drummond. And then moving forward to 61, which is on page 482, you can see the FTT's finding is quoted. And you can see that the FTT did find that there was a duality of purpose in that case. I'm just above H. SA and FM's intentions were plainly to secure a far from ordinary tax deduction, one that would not ordinarily be expected, and certainly one that was designed to achieve the very opposite of the result intended by Parliament. On this ground, we consider that the resultant duality of purpose in making the contributions is the very factor that occasions the fatal duality of purpose that results in the denial of the deductions. So that's the FTT's conclusion. And then on 484, we see what the Upper Tribunal says about that. I'm in paragraph 69. I'm just below the letter B. It seems to us that the FTT's conclusion must therefore have been not simply that the purpose of the scheme was to produce a tax deduction, but that the purpose of the contribution was to produce a tax deduction. That is why there was a duality of purpose. And that's the finding that the taxpayer then tries to challenge in Scots Atlantic. And in 72, the tribunal explains, 72 to 74, the tribunal explains why that challenge fails. So 3 lines down in 72. It was not argued that there was no evidence before the FTC on which it could reasonably have held, at the time the company's incurred the expenditure, that one of the objects was to obtain a tax deduction. On that basis, it was entitled to find that one of its objects in incurring the expenditure was to obtain a tax deduction, and that obtaining a deduction was a purpose rather than an incidental or consequential effect of the expense, and that's the Vodafone language being used. They say, we therefore do not accept Mr. Thornhill's criticism. In the present case, the important words are, if in truth the sole object is business promotion. The premise of the principle is that the fact-finding tribunal has properly found there is a sole object. The principle is that if such is the case, then an incidental effect does not, as a matter of law, disturb that conclusion. But it expressly found that the companies had another object. In doing so, it recognised that an incidental consequence of tax deduction did not mean that such a deduction was necessarily an object. And then 4 lines up from the bottom of 74. But if the fact-finding tribunal concludes that its inquiry into the mind of the taxpayer revealed that the taxpayer actually had that other purpose as an object of the expenditure, then the fact that the result is a natural consequence of the expenditure will not cause that finding to be perverse. So Scots Atlantic shows that even where a duality of purpose is alleged, that too is a question of fact for the tribunal. The question is whether obtaining the corporation tax deduction was merely incidental, or whether it was a purpose in and of itself. That's a question of fact, and that's a question that can only be challenged by way of an Edwards and Bairstow challenge. So, the last thing to show you is the FTT's finding of fact, because that's what I say can't be interfered with. And that's page 201 of the core bundle. It's paragraph 159 sub 2. And it's the end of the second line there.
Sorry, which page are we on?
I'm on page 201 of the core bundle. I'm in paragraph 159 sub 2.
Yes.
And I'm at the end of the second line. I cannot see that MDPL can be taken to have had a separate object of obtaining a tax deduction in laying out, expending, or incurring the relevant expenses. The obtaining of a tax deduction for the relevant sums is, as it was put in Scots Atlantic, the ordinary, intended, or realistically expected outcome, or, as it was put in Vodafone, a consequential or incidental benefit of expending sums. Now, the member in the tribunal disagreed with that. He said, I think it was a purpose in itself. But Judge Morgan's view prevailed. She had the casting vote. So just rounding that off, if HMRC wanted to challenge that in the Upper Tribunal, then what they needed to do was to make an Edwards and Bairstow challenge. They didn't do that. So the finding at 1592 cannot now be impeached. It couldn't be impeached in the Upper Tribunal, and it can't now be impeached.
Was this argument made to the Upper Tribunal?
That an Edwards and Bairstow challenge is required. It was, and it's paragraph 116 of the, so it's in the supplementary bundle. It's tab 8.
Right.
It's page 204 of the supplementary bundle.
Thank you.
So this is Mr. Firth's skeleton argument in the Upper Tribunal.
Yeah.
And it's put in terms. It was a finding of facts. HMRC have advanced no Edwards and Bairstow basis for challenging it, and then Scott's Atlantic is quoted.
Yeah. And did the Upper Tribunal explain why it rejected that contention?
It doesn't even deal with the question of Edwards and Bairstow.
Yeah, I mean, so far today we've looked at the principal judgment of the Upper Tribunal. I'm aware that there was a subsequent hearing and judgment. But at no stage, is it your submission, at no stage did they address the taxpayers' argument that this was an Edwards and Bairstow challenge, if it was anything?
That's right. So the result of all of that is, if ground 5 is a live issue at all, then in reality you're left with one question: was the expenditure incidental? The FTT has given us the answer to that. The Upper Tribunal's disagreement should be ignored, and that is the answer on ground 5. So unless there's any questions or anything else I can be of assistance with, that's everything on ground 5.
Thank you. No check if there's anything else. No. Thank you very much.
And ultimately, that's the appellant's case for the appeal.
Ah, thank you very much. Yes, Mr. Goach.
Thank you very much. Just one short point on Mr. Blade's submissions on wholly exclusively. The passage he took you to, those observations were made by the FTT judge on a counterfactual, that if she had been wrong in finding that the payments into the trust were general earnings, wages, then she would have found that the payments were wholly exclusively with the incidental benefit of a tax deduction. So it's not finding a fact at all. So in my respectful submission, Marlborough are simply wrong with everything they've said about wholly exclusively. I'll make that good when I take you to the FTT judgment tomorrow, with the court's permission. But as I say, that finding that the learned judge made in the FTT was done entirely on the basis that if I am wrong and that the money going into the trust were earnings, then and only then is that an expense to the company, holding exclusively for the purpose of its trade, and the CT deduction is incidental, and you'd expect one of those. So I wanted to start with that. Excuse me, also, would you mind? Sorry, I just need to sort myself out.
Of course.
With the court's permission, please may I, with the time I've got, trail what I'm going to say tomorrow, because I hope that's going to be helpful. With the promise I'll make what I'm trailing, I'll make that good tomorrow, if that suits the court.
Yes.
Preliminary point, please. The structure of employment tax is actually important to this case. What you've got on the one hand is the tax treatment, the taxation of earnings, general earnings, and payments deemed to be general earnings. That's section 62. And the test there is causal. We all know that. It's a from test or a by reason of test. And that's why you've got cases like Hostrasher and Mays with relocation expenses, or Wilcock and Eve saying, well, which side of the line do these payments fall on? There's a family of tax charges, and I'll show you these tomorrow. The case where I was put in my place, Barclays, retirement benefit scheme. The tax charge clicks. It's triggered by a payment in connection with past service.
Sorry, I missed that last bit.
The tax charge, my lady, is triggered by a payment in connection with past service. And just to be clear, in Barclays, as I say, I was put firmly in my place. Some of the payments were made to widows. They weren't employees; they were widows. It was literally widows and orphans. So there it is. I've said it. Still, the tax charge bites, huh? Because the in-connection test is wider. Similarly, in a case like Mather, the question there is there a payment in connection with the termination of employment? Not employment, is it in termination, in connection with the termination of employment? Held, I'll show you tomorrow by the Upper Tribunal, wider than by reason of. And that's why Part 7A is in that family of employment tax cases. That formulation that Parliament was well aware of when Part 7A was enacted is supposed to be wide. So there's nothing mysterious. It's the opposite. There's nothing mysterious about a tax charge to employment tax, which is not a function of a causal test, not at all. And of course we have to grapple with what in connection with means. But it's separate from, different to, words of that nature, any sort of causal test. Now, this is what I'm going to say about the facts tomorrow. 1, the scheme was marketed, and please be reassured, I'm not going to ask to go to any of the documents in the unagreed bundle, nothing like that. I'm not going to disturb the findings of fact or attack them. I'm not going to do any of that. Scheme marketed as a trading deduction and tax-free loan scheme, both.
So a scheme marketed as both.
Giving a trading deduction and one that would give a tax-free loan. And that was the purpose of the scheme, that was fact. Both. 2, Dr. Thomas, he'd implemented the scheme when he was still a sole trader. So not a company. And the profits Marlborough made, those profits were net of what he paid the hygienist, the associate.
Sorry, net of what he claimed as.
Net, my lord, net of what he paid.
Oh, but he paid, yeah.
Yeah.
Right.
3. This scheme, Marlborough pays money to the trust. At each contribution, there's this 10% fee to the scheme promoter. At that time that Dr. Thomas, as director, made that resolution, sole director, made that resolution that Marlborough would pay money to the trust, the contribution, he knew he'd be writing to the trustees or to his personal service company for a loan that he hoped was tax-free. He knew that. The entire loan was funded by the contribution. That's where the money comes from. This contribution was not quantified by reference to shareholdings. The contribution had this dual purpose, the CT deduction on the one hand and funding this tax-free loan on the other. And then you've got this collection of facts that the FTT found. One, the reason given in the resolution for this contribution to be made, this these fake deductions, the fake reasons, they were not true. Dr. Thomas had no contractual right to the contribution or loan. If Dr. Thomas had not done this scheme, he would have taken dividends. Bracket, bear in mind, he had already done this scheme pre-incorporation, close bracket. He takes dividends now. Other shareholder directors take dividends out of their companies. The loan provided a return on his investment, and that's because the way that these contributions were quantified, they emptied the company each year, you'll remember, of its profits. Having paid everybody that needed to be paid, that's what went into the trust. Dr. Thomas was the sole director and sole shareholder. Now, I wonder, please, if the court, please, may look at Part 7A and it's section 554Z2. So that's tab 2, page 63 of the electronic bundle. Please, does the court have that?
Yes.
Now, what this section's doing, along with 554Z3, where else would you look for the tax charge? Anyway, if you've got a relevant step, if you've got one of those, and here we've got at least one, which is the loan. If you've got one of those, it counts as employment income of A. That's the employee. That's Dr. Thomas. Please, would you look at little 2? Little a, if there's an amount which we'd be treating as earnings, so that's normal wages, or, this is important, any income of A which apart from this subsection would be treated, which would be dealt with under Chapter 3 of Part 4 of Vitoia 2005, that's distributions, that's dividends. Dividends and any other distributions. That's what 2B is looking at. Then, sub 1, in other words, Part 7A takes priority. So not having it, that there's a bright line distinction between distributions on the one hand and Part 7A on the other. And if something's a distribution, it can't be in Part 7A. The draftsperson thinks the opposite, at least for the relevant step. Now, that deals with, because this may be convenient to close on this, there's been a lot said to the court and the tribunals below about a distribution. But the identification of this distribution is still quite puzzling to the revenue. It's either contribution and the loan, because it's the loan that gets the money into Dr. Thomas's hands. But if that's a distribution, if the loan is a distribution in combination with the contribution, that's an extended meaning of what a distribution is. The revenue do not say a loan can never be a distribution. We're not saying that. I am saying, in listening to Mr. Firth's submissions about distributions and double tax, if the relevant step is the loan, which it is, if that's the distribution, that's a return on Dr. Thomas's investment, Z2 takes priority. Part 7A takes priority. It just does. Second, say the loan isn't a distribution, and the FTT seemed to think it was the loan. I'll take the court with the court's permission to that tomorrow. Say it's the contribution that's the distribution. So this is a kind of Rangers type analysis where Dr. Thomas has said, oh, don't pay me the dividend. Well, not my mama, but pay these friendly remuneration trustees. And I'm very happy with that because they're going to lend me money. There, Mr. Firth says, oh, that's double tax right there, because then Dr. Thomas may get taxed on that distribution. But crumbs, then he gets taxed on the Part 7A loan as well. Now, if that's the distribution, if it's the contribution that's the distribution, that 2017 legislation I gave Mr. Firth at lunchtime, because I waited over the course of the morning to see if he'd refer to it. That isn't just subsequent legislation, that is retrospective legislation. So what happened was, it's true, the revenue thought they were going to lose Rangers. I mean, they didn't, but they thought they were. But then they won. And they won on the basis that the payment to the trust was earnings. And they needed to deal, Parliament needed to deal with, well, now we've got this legislation that's going to tax the loan as well. We don't want two lots of tax. Parliament, you saw an old version of 554Z5 that talks about if you've got two relevant steps, well, don't worry, you'll only be taxed on one of them. This is a different problem, where there's a prior payment which is taxable, but which funds or one way or another gives rise to a relevant step. Parliament dealt with that in 2017 retrospectively by saying, well, don't worry. Put short, and I'll make this good tomorrow. Don't worry, so long as the tax is due and payable on this earlier step, you won't pay tax twice. And I will
Is that a
make that.
disapplication then of Part 7A?
Yes, it's inevitably more finicky than that, but the big message was.
If you pay tax as earnings at stage 1, you can disregard or in some way not get caught by it.
Or distribution.
Or
Yes. 'Cause what-
or distribution.
It's any old income tax.
Yep.
Oh, sorry, I'm going to do that at the end. Sorry, typically Ms. Belgrano was telling me to do something which I will do. I'll just do it at the end. I was going to say something. Yes, I'd like to say this. If I can close on this, not close, but leave you with this thought. It's been said, and it's been said throughout this hearing. And sometimes I wake up thinking the world, you wake up thinking the world's round, and you end up with a judgment. You think, blimey, it's flat. What I have been arguing for the revenue below is, look, this is earnings. I'm the sole director. No distribution. The Upper Tribunal found that the contribution wasn't a distribution. It's what's funding the loan. The only other candidate is my directorship. It's not a gift. That's not open to me now. So I understand that. But what you've got is a scheme in this family of tax charges, which is wider than causation, where Dr. Thomas is the sole director. So his shareholding is no part of the mechanism of this arrangement. Nobody's suggesting that. I have to accept it's a return on his investment. Call it that if you want, that's fine. He drafted a resolution qua director, knowing that he was going to get that money by way of loan. He chose himself. If you want to go there, who did he choose to get that money? Him. So in other words, his directorship is central to him getting that money. In a world in which he's the sole director. That's what I meant, but I didn't just say his directorship explains the loan. I said exactly this. So yes, it's not a causation test. This contribution wasn't caused by his directorship in any traditional sense. That ship has sailed. I've lost that point below. But on any view, as my Lady Justice Whipple said, on a reasonable to suppose test, taking into account all of the relevant facts and circumstances, this case is easy. I'm a director, I'm the only director. I am resolving that this company contributes this money to that trust, knowing I'm going to get that money as a loan. That's your connection right there. The directorship is part of the arrangement and it's centrally connected to the loan. It's a stronger connection than the widows who were taxed under Barclays. I don't want to keep going on about Barclays. I will move on. But that's the connection, my lords and my lady. And in my respectful submission, I shall show you tomorrow why notions of predictability, consistency, certainty, as well as a coherent location within the employment tax charge, none of those are offended by what I have just said. That's my case. what the Upper Tribunal said was, oh, well, that's not enough of a connection. But bearing in mind he's the only director and he's paid everybody that needs to be paid. So the reason the money went into the company is because he's a director. That gets you over the line. I'll deal with that tomorrow. But I'm saying in a world in which I'm a director, I engineer money paid to a trust, knowing that that money is going to fund a loan to me, how can that be not connected to my directorship? And I'll close on Clipperton. Clipperton wasn't a loan, so it's not open to the revenue to run Part 7A, where there's a loan in connection with a directorship. They couldn't have run that. So the dividends would have had to have been on the evidence, a reward, a recognition of directorship, and that wasn't the case. It wasn't that. It wasn't that. Nobody's saying it was that. It was a different scheme. I'll extract money trying to get tax-free dividends effectively, or I'll extract money using my directorship by getting me a tax-free loan. There's no tension. So that's all I want to say. There is a danger in my respectful submission, just like the submissions made about findings of fact on wholly exclusively, that the archaeology of this case, the simple points I'm making get lost. I say there's a connection. I say it's visible. Even if the loan is a distribution, so what? Just respectfully. So nothing. If the contribution's a distribution, that's dealt with, albeit retrospectively. You can't just dismiss 554Z, B and ZC as subsequent legislation. It's retrospective. Please may I finish there and pick it up again tomorrow morning?
Yes, and how much time do you think you'll need tomorrow?
I'm hoping, I'll certainly give Mr. Firth, as we've arranged, minimum an hour to reply, but I'm hoping to be finished, I can't promise, but I'm hoping to be finished by 1 o'clock, by lunchtime.
All right.
I can't promise, but I hope that.
I understand, but it's helpful to have that indication. And should we take the
Oh, yes,
provisions with us?
Please. There's less to that than meets the eye, I promise. It just tells you there shouldn't be double tax retrospectively, and there's also, I think, the charge for distributions that I showed you.
Thank you very much. We look forward to hearing you further at 10:30 tomorrow.
Court rise at table.